Welcome back to the program. It's exactly 14 minutes past the hour. Now, Ugenya Member of Parliament Chris Karan will this afternoon know his fate as the Court of Appeal rules on an appeal he filed against a petition challenging his August 2017 win. The petition was successfully sponsored by the immediate former MP David Ochieng. Now, let me take you over to the lakeside city of Kisumu, to be specific, the High Court there, for the live proceedings as it's happening now at this moment.
Summarized what the appeal is about, the grounds of appeal, the submissions that were made by the respective councils. Then it goes to the analysis and determination, and this is the part that I shall endeavor to read, though not necessarily what. The of the appeal and cross-appeal is one that impacts on this court's jurisdiction to hear the appeal. Therefore, it's appropriate that I commence the analysis by considering whether the grounds that have been raised in these documents fall within the meaning of matter of law as elaborated in the Munya decision. According to the first respondent, the cross-appeal is incompetent in its entirety, while the appeal is incompetent in part from grounds 5 to 9. This is because, in his view, issues of fact instead of issues of law have been raised. Rule 6 of the 2017 Court Rules provides for the filing of a notice of appeal, while Rule 10 of the 2017 Court Rules provides for the filing of a cross-appeal. Unlike the 2010 Court Rules, which provides for the filing of a notice of appeal as per Rule 75, and a separate 2017 Court Rules does not require the setting out of the grounds of appeal in the notice of appeal. Therefore, a respondent would not be able to know the grounds upon which the judgment is challenged by relying on the notice, nor would it be clear whether the appeal falls within the limited jurisdiction provided under Section 8. An appellant in an election petition appeal to this court should file a memorandum of appeal in accordance with Rule 86 of the 2010 Court Rules, setting out grounds of the appeal in which the points of law upon which the appeal is grounded is concisely and precisely set out under distinct heads and without argument or narrative. The appellant filed a record of appeal containing a memo of appeal. The issue of time does not arise as the record of appeal was filed within 30 days, in accordance with Section 85A of the Elections Act. The memo of appeal raises 9 grounds that are clearly set out. And of proof to the second and third respondent without the first respondent cross appeal. Rule 10 sub 1 of the 27 Court Rules provides how that for drafting, I clearly discern issues of law, such as issue of non-joinder of parties, whether the standard and burden of proof was properly applied, whether the election court improperly determined the appeal on unpleaded issues, and whether the election court properly applied the test of transparency, accountability, verifiability, and credibility in determining whether the elections were in accordance with the Constitution and relevant. I reiterate what this court recently observed in Ugenya MP and another, but compels a party who wishes to appeal against interlocutory decisions to await the final judgment of the election court. As already adverted to in this judgment, following the ruling of the election court delivered on 21st November 2017, the appellant did not take part in the proceedings. A question therefore arises as to whether he can challenge the outcome of those proceedings on issues that he did not have an opportunity to take part in. But I'll not read those ones. I'll go straight to the issue on the appellant's right to a fair hearing. The issue concerning violation of the appellant's right to a fair hearing emanates from the rulings of the election court delivered on the 16th and 21st November 2017, by which the election court first declined to admit the appellant's response to the petition that had been filed late, and in the second ruling denied the appellant the opportunity to participate in the proceedings, maintaining that the appellant had lost audience before the court after his petition was struck out. Both the appellant and the second and third respondents are of the view that the court improperly exercises discretion in taking the draconian measure of striking out the appellant's response to the petition. According to the appellant, the court acted in disregard of the fact that as the candidate whose election was being challenged, he was a necessary party for the court to be able to make a holistic and fair determination of issues at hand. In addition, the appellant faulted the court for declining to admit his response despite having allowed a similar application by the second and third respondents, and also failing to consider that the delay had not affected the proceedings. He questioned the court's finding of perjury against him, contending that there was no proof beyond reasonable doubt, particularly without the aid of a document examiner, to determine the authenticity of conflicting letters that were produced by the appellant and the first respondent. In the ruling of 16th November 2017, the election court declined to exercise its discretion to allow the appellant to file his response out of time, stating in part as follows. We've quoted from that ruling, but I will not read that. The issue of determination here is whether the court, in so finding, exercised its discretion that ruling. Upon being served with a petition in accordance with Rule 10, a respondent may oppose the petition by filing a response to an election within 7 days. In regard to this rule, the election court observed that, and I quote, "The rule does not make it mandatory for a respondent to file a response. A respondent who opts to file a response must, however, file and serve it within 14 days from the date of service of the petition." This was an error, as Rule 11, Sub-Rule 1 of the 2017 petition rules requires that a response to a petition should be filed within 7 days, and not 14 days as stated by the election court. Under Rule 19 of the 2017 petition rules, the election court had discretionary powers to extend time provided by the rules in the following terms. That rule is set out, but I'm not going to read it. This rule has to be read together with Rule 5, which requires that the effect of any failure to comply with these rules shall be determined at the court's discretion in accordance with the provisions of Article 159 2D of the Constitution. Rule 4 of the petition is also Rule 4 is also a guiding consideration as it obligates the election court to give effect to the objective of the 2017 petition rules, which is to facilitate the just, expeditious, proportionate, and affordable resolution of election petitions. In Martha Wangari Karua versus Independent Electoral and Boundaries Commission and 3 others, 2018 EKLR, this court underscored the need for the election court to balance all these objectives before exercising its discretion to strike out any pleadings. I also take note of the guidance given by the Supreme Court in Nicholas Kipto Salat versus IEBC and 7 others regarding the principles that should be taken into account by a court in exercise of discretion for extension of time. I set out the principle herein verbatim. The principles, 7 principles have been set out, but I'll not read that. I also bear in mind the well-settled principles that guide an appellate court in considering whether to disturb a court's decision arrived at in an act required under the rules of procedure is not a matter of right. A party seeking the court's indulgence where there has been non-compliance with the rules must demonstrate that he is deserving of the exercise of the court's discretion in his favor. The fact that a similar application made by the second and third respondents for extension of time was allowed would not of itself be a basis for allowing the appellant's application. The election court was required to consider the circumstances of each case. Indeed, the reasons given for the non-compliance was not the same. Besides,
well, that is